Welcome to Bordeaux's Boardroom, episode 4. I'm Jerry Bordeaux. This is my podcast. I'll explain a little more about who I am in a few minutes. First, I wanted to say that if you have caught the previous 3 episodes of my podcast, you are likely a condominium person that I know. You either own a condominium, or you work for a condominium, or you manage a condominium, or you're a condominium lawyer, or something like that. So, to my condo peeps, I wanted to say first that I'm glad you're here. Don't leave, even though this is not directly condominium content. This is something that will affect condominiums in Ontario, and indeed might affect you personally, and will affect really everybody who lives in Ontario, and probably people who live elsewhere in Canada as well. And that's because jurisdictions tend to poach from one another when they're organizing their legal systems. And indeed, we're going to talk more about that later too. So, what am I talking about today? The Ontario Superior Court of Justice has decided to engage in a review of its rules of civil procedure. Right. So, for the non-lawyers watching this, the rules of civil procedure govern how litigation is started and conducted in the province of Ontario. Most jurisdictions have some kind of similar, set of rules or some kind of code or even tradition about how litigation's carried out, and this is the one for Ontario. And what's the problem here? Why is this happening? Well, according to the Ontario court, uh, and as described by the Globe and Mail, where can I find it? The court system in Ontario is arcane and out of date and costly. Um, Here it is, arcane, expensive, and plagued by delay. In short, it's in crisis. What's even more troubling is that this description is hard to dispute. So that's according to this Phase 2 consultation report of the Ontario Superior Court of Justice. So today I'll be talking about this idea that the court system is essentially busted or busting. Um, and I'll be talking about this report in a rather critical way, although I hope in a rational and productive way, and giving you some background on it, my thoughts on it, and some things that I hope people will consider going forward. I'm also very happy to receive feedback about the ideas I put forward in this video. I like to receive feedback on my ideas. It helps me to sharpen them. And this is a big issue. So it should be a discussion more so than either a dictatorship or a debate, right? So, um, first thing that I will do is point out some of the things, give some caveats, explain some of the things that I like about this report, and just make clear what I am not criticizing because I don't intend to insult anybody who's involved in this report. Um, so First thing I like about the report is that, contrary to other reports that I have seen for the purpose of guiding legislation and informing government, at least in the Phase 2 version, which is not the final version, explicitly says that it shouldn't be relied upon, that there is actually dissension within the working group that produced this report on a lot of the topics in it that it recognizes are somewhat controversial topics at times, and it is seeking broad feedback, and or the working group is seeking, the court is seeking broad feedback. That's nice to see. I really hope that they take into account as much of that feedback as possible, because, like I said, I have seen other reports of this nature. One in particular that I had to study when doing one of my law degrees, and it was about consumer credit in the United Kingdom, and a particular report that has literally cost citizens of the United Kingdom, subjects of the United Kingdom, billions of pounds over the decades. And of course, when something costs society that much money, it is not just a financial loss, right? That this is a human felt loss. It's a reduction in standard of living. It's an increase in stress and psychological stress. It's a decrease in everyone's well-being, right? So these sorts of reports can be very scary sometimes because they can lead to extremely bad outcomes, and that's often not appreciated, um, especially in places like Ontario that are very used to handling issues through legislation, right? So, if you have a sort of top-down model of repairing a situation, and it's sort of all or nothing. You better get that right because the whole system adjusts at once, and if it's wrong, it's extremely dangerous. So I want them. I'm glad that they know they need to be careful about this, and I want them to be careful about this. Another thing I want to clarify is that I am not trying to criticize any individual involved with this report. So on one of the pages coming up here, they list the working group, and this working group, I believe it's the same one that uh, took part in the phase one report, which I'll mention again in a moment. This working group is filled with people that I have no doubt have good intentions, and in fact, I respect that they see that this is happening. They're willing to try on their own time to participate in making the system they work in better, right? So that they're not under any obligation to do this volunteer work, and yet here they are. And all of these people are very high functioning people that I'm sure have other things that they could fill their time with and have chosen to try to guide this process. Um, and I believe that they really are trying because, as I mentioned, this phase one report is very interesting. It's from May of 2024, and the report is mostly qu analysis of questions that the working group was asked. So, to return here for a moment, something you're going to notice, and this is a criticism I have, um, the participants they all have something in common, okay? And that is that they're lawyers. If they're not working attorneys, they are teaching in law school or they're sitting on the bench, right? So, for all intents and purposes, these are trained lawyers, all of them. Um, and they were asked questions about the civil procedure the way it is right now and what should change. So, for example, should we consider a broader role or broader role for applications as a paper-based, discovery-free alternative proceeding? Now, the concept of a paper-based, discovery-free alternative proceeding is horrific to me, and I'll explain why later. Um, but take a look at this. Not everybody is in agreement here, right? So, and the phase two report recognizes this. So, eight people say, yeah, we should consider that. Six people say we shouldn't even consider it, and six people say they don't have an opinion on the matter. And by the way, I don't believe these six people. Well, when was the last time a lawyer didn't have an opinion on something? Um, there were other questions like this. Should we consider permitting a wider range of digital service options, including for originating processes? 17 say yes, 3 say no, no opinion, 0. I can believe that. This is valuable, I think. I think that asking lawyers about their experience in the system and what they would like to see changed is part of what the province should be doing and or the court should be doing and taking into account. Um, and indeed, I'm not surprised to see that the lawyers would prefer to have the system modernized electronically. And I'm also not surprised, and in fact, I'm a little encouraged, though, to see that some lawyers don't think we should even consider a paper-based, discovery-free alternative proceeding for applications. Um, so why am I saying this? Because I want to temper my criticism a little bit. And again, for the things I'm going to point out, I put 0% of the blame on any of these people. I think that they're all doing their best, and I appreciate it. And I also appreciate that they don't all agree and that they are just fine with admitting that they don't agree. And I think those are the nicest things that I can say about this report. Oh, and I should say also that some of their practical solutions to different matters, like making case management more efficient, case management being just the administrative process of setting dates and deadlines for a case. I think that's fine. There's a lot of solutions or things in here that I think are not terribly controversial and probably would have been done a long time ago, where we're not talking about basically a, a government department here. Um, right. So, and just to prove my point, remember that question about modernizing to the electronic age. Well, I mean, businesses have done that 30 years ago. But nevertheless, better late than never, right? Now, um, I want to also say at the outset, because I'm going to get into some more technical, heady sort of space in a few minutes, that if you're going to take anything away from my criticism here, it's that this report is not adequate to resolve the problem that they pointed out, which I had read out earlier, that the system is arcane, expensive, and plagued by delay, and that the court system's in crisis. Um, the reason for that is that it's only asking lawyers, right? And our lawyers, should they be asked? Yes. I mean, they deal with the system all the time. They're going to have some ideas and opinions. And additionally, I don't want it to come off like I don't like lawyers, because that would be silly. I have, as I alluded to before, completed two law degrees, one a bachelor's of law, another is a master's of law. I have passed the uniform bar exam in the United States. I've applied to take tests in Ontario, which is a whole other topic I can get into in another episode. But suffice to say, I'll be sworn into the bar in DC later this year. And I work with lawyers all the time, and very much respect the profession and the people in it in general. So I'm not saying that lawyers are not smart or capable. Quite the opposite. I know that they are. And some of these people in this list might have extra skills I don't know about, right? And that's great. And to hear I'm referring to this working group. But you're only going to get, in general, a slice of you're going to get one perspective, right, from a lawyer. I mean, they might argue about the law, but you're still talking about the law. And what needs to be reformed here is not necessarily the ins and out of civil procedure. And I'll explain. But I think that if I could send away the court with one bit of advice, it's please hire some, or get some, however you do this, economists especially. You should probably look, if you want to know why a system is suffering from shortages, which that's what this is, and why there are costs that are astronomical, and why all this dysfunction is happening in this sector of society. It's not a lawyer you want. You want to talk to an economist, right? That's their job. That's what they study. I do have a background in business economics. I have both a formal training, and I have probably read more about that subject than I've read about even the law, just on my spare time. But additionally, I wouldn't stop there. I would also think that they should talk to psychologists or psychiatrists. They should speak with medical doctors, and I'll explain why later. You also should consult with, if you can find some, moral philosophers and political philosophers. And why do I say this? Well, because some of what we're going to discuss boils down to values and morals. What does a society value? How does that, why should it do the, value what it does? What do people value and why? And some of that, there's overlap in psychology as well. But additionally, for the political philosophy, what political philosophers tend to be good at doing is, and there's overlap with economics here, is telling you what the outcome will likely be of a system that you design, right? So that's what we're talking about here is we're coding a piece of society and we're wondering how is this program, once it plays out, how is it gonna, what's it gonna look like? Is it gonna make the system better or worse, right? And I think a political philosopher who is an institutionalist, which is something that I very much am, would remind everybody that the purpose of the system isn't the system itself, right? The purpose is what can it do for people? People are alive, not the system, and people are the ones that rely on the civil law system that we enjoy, right? I don't think the drafters of the report disagree with that. But I do think that it is a just something valid to keep in mind as we discuss how the system sort of came to be in the first place and what is our goal, right? Because if the and I know the drafters would agree with this, if the system's not working for people, it is useless, right? We don't just want a justice system for the sake of having one. Which brings me to another topic that is touched obliquely in this report, which is that civil law is, I think, actually more important and scarier than criminal law. Um, so, what do I mean by that? To the individual, criminal law is definitely more impactful immediately, right? There's this physical threat of being taken away and locked up. And that's why we have in the Charter of Rights and Freedoms in Canada some guarantees about what has to happen before before you get locked up in Canada, and that's good. I'm glad that's there. We don't have the same sort of, I'll call it, due process promises explicitly in the Charter. There is a history of due process concerns, obviously, in the common law and in Canada. But uh, I think that it's a mistake to think that criminal law is somehow more important than civil law. You can mess up. Look, if I was going to try to mess up society, um, I wouldn't start with criminal law. People are not likely to accept um, just outright kidnapping by the state. You have to kind of get there, right? The history indicates you have to get there because of a breakdown in your social institutions. And by social institutions, I don't just mean the government. I mean the way that we interact with each other, right? And remember, civil law is private law. And most of what Canadians do on a day-to-day basis is governed not by criminal law, uh, it- but civil law, right? I mean, Canadians are not typically murdering people or stealing things. Yeah, th that happens. There's a portion of the population where that's a serious issue, and it's a big enough portion that we have to have a system in place to deal with that. But more than likely, if you're listening to this podcast, you are affected on your in your daily life by contracts and business and family law and that sort of thing, uh, far more than criminal law. And if we get civil law wrong, we can really mess things up. Keep in mind, like civil law, fine, you're not going to get thrown into a box, but you could have your kids taken away, right? You could lose access to your offspring. You could be financially destroyed through civil law. Your business it could wreck the lives of hundreds of people. You don't think that might cause some issues, some distress, some suicide, perhaps? Um, if society stops making sense, then unfortunately, that's when the criminal law might get busier, right? So, and there's a really great quote about this actually at the start of this report. So it says the need for reform, and then it goes into Professor Dame Hazel Jen or Gen. I'm sorry, I don't know who this person is, and I hope I said one of those correctly. Um, so this person has this quote: "The machinery of civil justice sustains social stability and economic growth by providing public processes for peacefully resolving civil disputes, for enforcing legal rights, and for protecting private and personal rights. The civil justice system provides the legal architecture for the economy to operate effectively, for agreements to be honored, and for the power of government to be scrutinized and limited. The civil law maps out the boundaries of social and economic behavior, while the civil courts resolve disputes when they arise. In this way, the civil courts publicly reaffirm norms and behavioral standards for private citizens, businesses, and public bodies." Right? So we rely on norms, norms being just how do you normally deal with something? What are you used to? Like shaking hands, smiling, um, being honest, right? These are things that are normative in society that, frankly, much more than the law, grease the wheels of human cooperation. And remember, humans far predate the law, right? How old is Hammurabi? A few thousand years ago. Um, Common law, sure, it seems old to us. We only live, whatever, 70, 80, 90 years if we're lucky. But human interaction started long before that. And if civil law comes around and starts messing with the norms that keep people interacting in a civil way, this is intensely destructive to society. So this is really important. This entire um, this entire exercise is really important. And just a quick note on the common law too, which is the ancient judge-made law that originated in England and is the basis for the justice system in the United Kingdom, Canada, the United States, Australia, New Zealand, and probably some other places I'm not thinking about. That law took centuries to mature and evolve and to adapt. And it is a lot of wisdom, right? That was painstakingly discovered by judges and society through the ages. And we should be really, really careful about switching on a dime to other systems, other ways of doing things when we are living in a common law society that really has grown up in that tradition. It's very dangerous to do that. In fact, is it impossible? I don't know, but it's not something you do without thinking a lot about it, right? Um, so as soon as I started reading this report, which was sent to me a few days ago, and I just haven't really been able to get it out of my head since, on page 2, I came across this paragraph that sort of made me despair, and I'll read it for anybody who is not watching the screen, right? So here it is. This is from the report. Some argue that what ails the system is not the process that governs it, but insufficient resources. While additional resources would undoubtedly help alleviate delays in the system, they would do little to reduce the overall cost of litigation. Regardless, the concept of additional resources is not a viable solution because, as the saying goes, the cavalry is not coming. In the result, we must either accept the unacceptable status quo or, having regard to our existing resources, critically examine our current processes for managing civil disputes to improve their efficiency and reduce their delays and costs. The Attorney General and the Chief Justice of the Superior Court have directed us to do the latter. So the Attorney General and Chief Justice apparently have just accepted that no resources are coming, And so we want you, a working group of lawyers, we want you to critically examine the processes we have now to just try to improve things with the resources we have. Now, it's not insane to want to improve things with the resources you have, but it's not a solution either, right? There is not going to be a solution to the crisis that is apparently occurring in our courts, one that, for reasons I listed out, should really be very concerning to anybody in society, relying on civil norms and all those other things that I discussed, right? Um, you don't want to hear a really severe problem like that and then just read that the court has decided, well, you know what, just do your best with what you got. It's not very comforting. But also, this paragraph is just incorrect in a number of ways and contains some weasel words that I really don't like. Um, so, for example, some argue that what ails the system is not the process that governs it, but insufficient resources. Who? Who is arguing that, and where are they in this report? Um, They, I bet most argue that what ails the system is not the process, but insufficient resources. I bet that most lawyers think that, and I would like to see the data on it, actually. They would be interesting. I mean, wouldn't that be pertinent to know before we undertake these changes if the real problem is a lack of resources? Now, and this hand waves it away by saying, well, the cavalry's not coming, so the resources aren't coming. But why? Why aren't they coming then? Is it just because the government doesn't want to spend more money or can't spend more money? Well, there are other ways of doing things. And besides, if we dig a little bit deeper, that story doesn't really make sense, and I'll explain in a moment. But um, my point here is that this is already degenerating into a Band-Aid fix, right? And it's not not encouraging. But take this sentence, for example, okay? While additional resources would undoubtedly help alleviate delays in the system, they would do little to reduce the overall cost of litigation. There is no economist that would agree with that. That is impossible. And with due respect to whoever wrote that sentence, this sentence is just factually incorrect. And unfortunately, it's used to set up the false dichotomy that follows, right? So the false dichotomy being that we either have to accept the status quo or rearrange the deck chairs on the Titanic. So they're basing that dichotomy on this sentence about additional resources alleviating delays, but just wouldn't affect the costs. Well, how can that be, right? So I want to jump into a little bit of economic reasoning here. There are different costs that this report conflates and doesn't do a good job of delineating that make litigation expensive. One of them is not the court fees. The court fees are cheap. You don't pay a bill for the judge's time, right? The judge is on the public payroll. The judge is um, subsidized by the taxpayer. That's not what the litigants are paying for. So why are there so many delays in the public system? What? Well, it's because it's free, right? It's called the tragedy of commons. It is so easy to to use that watch it go. It's going to be just plugged up. Um, but then why is litigation so costly, right? Well, litigation's costly because of the lawyers. The lawyers are costly. Why are they costly? Well, the lawyers are costly because there's not enough of them, right? So if you include having more lawyers into the definition of more resources, right? So if we have more lawyers, more judges, more courtrooms, undoubtedly this would reduce the overall costs of litigation. It, and I'll tell you why, and it's just in common sense terms. Imagine that you have 10 cars that you want to sell, and you have a million people that need and want cars. those 10 cars are going to be extremely expensive because you have so much pent-up demand and only so much supply. The people who need those cars the worst, the absolute most, they're the ones that are going to pay for those cars, right? And then everybody else is stuck doing whatever it is they're going to do. Well, if you have more cars, the price per car will go down, right? You're going to have to, especially if there's competition, etc. You're going to go towards equilibrium in the market, in a competitive market. And obviously that's not happening with lawyers. Why is that not happening? I mean, you have um, people who need lawyers, and the costs are going up. The hourly costs are going up. Well, because like the cars, the supply is too low. You have a very high bar, pun intended, to entry into the profession. You have to do many, many years of schooling. Um, you have to be a certain type of person, of which they're not necessarily, you know, the entire population can necessarily has the characteristics to be a lawyer. Sometimes it can take a lot of time to develop those characteristics too, but it's also a very risky, difficult job, and it requires a lot of work and money to get going in it. Um, and a lot of those barriers are frankly just arbitrary. Like, for example, you used to be able to just get a bachelor's of law. And that was the degree you got to be a lawyer in Ontario. Then it was decided that no, you're going to get a bachelor's degree in literally anything before you can go to law school, right? And why? Why? To make a more well-rounded lawyer? Well, yeah, but then you get plugged into a system where you're going to be just sort of slave to the system, right? So to speak, um, which is part of the complaint in this report, ironically. So I guess what I'm saying is if you make it easier to be a lawyer and train lawyers and get other human resources into this and you have more judges, in fact, the cost of litigation would drop. You'd have more competition, more supply, more people getting the services that they want, right? There are other things to do as well to help this scenario of access and cost that I'll mention later. Um, and that's basically how you fund lawsuits. And this report doesn't address that at all. Um, but what we're facing here, when you see these shortages and we have people paying for the court system not only through taxes but through wait times, which is just another cost, you have economic dysfunction, right? The supply and demand curves are not meeting at equilibrium. They're way off. And they're way off because there's been an intervention in the market for legal services. And who does that intervention? Well, it's the government. And it just is. There's nobody else it could be. And now the government has not done the planning from on high correctly. And instead of saying, look, we need more resources, they're saying, let's just shuffle things around. Now, if you compare to other things that the government runs, and I'm not trying to be political here, there's a whole economic literature about this. This should not be surprising and is entirely explicable. In fact, it's also entirely expected. Um, if you look at in, and I believe every political party in Canada now accepts this. So hopefully this is not too controversial because it's really not the point of my podcast. Look at housing in Canada. It's so expensive. And generally people are saying, well, that's because the government picked the wrong number of immigrants to come to Canada. Well, if you had left that to a market, that never would have happened because the person who is sponsoring or bringing in another person from somewhere else would know that they have nowhere to house them and they wouldn't go forward with this, or they'd be forced to house them at their own house or figure out something, right? But the government did the supply and demand curves wrong on all of this, and now you have wacky housing prices and people waiting to get into a place to live. It's no different. It's the exact same scenario, right? But this report unfortunately doesn't want to address it. Another good comparison between the provision of legal services and the housing market that I was just discussing is a concept called elasticity. The reason the two markets are comparable is that you need housing. That's not an option. And normally, when you're getting a lawyer, it's because you need a lawyer. Nobody does a what do you call that? When you're at the checkout and you just do you buy something on a whim, right? Nobody just on a whim goes out and gets a lawyer just for the hell of it, right? You're usually either trying to get something done that you really need to do, a business transaction, buy a house, something like this, make a will, or you're in big, big trouble. And so lawyer prices are what they call inelastic. So is housing prices. What that means is that no matter how expensive they get, people still, this is just a lay way of saying it, people still have to buy it, right? So there are other examples of inelastic goods might be life-saving medication. You're going to pay whatever you have to pay to get that medication for lymphoma or whatever it is. You don't have a choice, right? And that's often the case when you're buying legal services. So lawyers, not enough of them. You really need them. You see the cost skyrocket. This is not surprising. Like I said, any economist would have predicted this, told you this, and can solve it. So again, takeaway, please invite some economists to comment on this whole thing. Now, something else I want to mention that this report doesn't get into, and that an economist would, or even a political philosopher would likely think of, is why is it that despite the fact that litigation is so expensive, that we have so much of it right now? Partly it's this inelasticity thing that I explained, but also partly the issue is that there are more rules, right? So this report complains somewhere in it that there are roughly 60,000 claims, either, I don't know, either an action or an application. There's some kind of litigation that is started per year in Ontario. It was some amount a little more than 60,000. Well, this would be very bizarre behavior, given the cost of litigation is apparently at a crisis, except for the fact that you are just, like I said, forced to do this often, right? To participate in this litigation and to deal with it. Somebody needs to do the following math, and it's just not done in here. Is the proliferation of bureaucratic rules causing more opportunity for litigation and thereby inflating the need for lawyers and this whole system resources. Now, it does get into it a little bit, ironically, with respect to motions and some other processes that we'll get into that are set out in the rules of civil procedure. So the lawyers can see it for their own field, right? But most of the litigation isn't litigation about the rules of civil procedure. Sure, that can happen if your lawyer blows a deadline or something like this, then maybe you're suing your lawyer about these rules. But typically, the lawyer is representing a doctor, an accountant, an engineer, just whatever, a business owner, and a condo corporation, and something has gone wrong. And the more rules, standards, technocratic, um, uh, 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 you know, benchmarks that you put in, the more you incentivize trouble too, right? That is potentially, to the point of this report, not substantive. You end up with procedural fights about a procedural wrong that is created and by the government and isn't something that necessarily people on their own dime would otherwise fight about, right? And where do you see this? Well, all over the place, but remember, this is also, and this is why I said I think that medical doctors and psychologists should be asked about this too. This manifests in burnout. Um, when you complicate all of these professional systems, doctors, engineers, lawyers, etc., you increase the burdens on them to get insurance that increase costs for everybody. You increase burnout and that they people spend all their time keeping up with bureaucratic changes, dealing with bureaucratic changes for their customers. So if you're an accountant, let's say, it's not just the accounting standards that keep going up and that you have to keep up with. It's also the increased amount of activity that your client has to go through to run their business and be compliant. Now you've got to account for all that too. And the more complex this gets, right? Not all accountants are created equal. The smaller portion of accountants, not to pick on them, are actually capable of competently handling these things, which means that you have more opportunities for negligence from the other accountants or doctors or whatever it is, condo managers, whatever, which means you have more litigation. You have more insurance responding. You've got more complaining. You've got more of a basis for a complaint. Maybe I'm beating this subject to death here, but I guess my point is that why aren't we talking about reducing the number of litigants in the system? Where are they coming from? Right? It's not from the common law. The common law has been around for hundreds of years. Are all of these litigants in there because of a pure tort action? I doubt it, right? That's not my experience at all. And so, I mean, maybe I'm wrong. Prove it. Where's the data in the report to show this, right? These are publicly available records. Any actuarial or statistician, again, more people that should be involved in a report like this should be able to pull that information together, do an analysis on it. Why are people suing, right? Why is this occurring? Is there a correlation between the increasing amount of legislation that we deal with and the amount of litigation we see in the courts and how slowly it goes? Right? I know where my money would be on the outcome of that analysis, and I know that that analysis has been done in other contexts and in other places. So again, this paragraph here really sent me for a loop. I had to think about it for quite some time because I just knew that I would have to temper my expectations for the rest of the report. There's just going to be a lot of deck chair shuffling. Um, so moving along, I mean, the report starts to go on about access to the justice system, which is really important. I mean, if people can't access the justice system, they just resort to settling disputes however they can. Um, One thing that this speaks of, it's sort of dismissive of, is private arbitration. And that's a shame because private arbitration is a perfectly sane and valid, proper thing to encourage, and is, it is legal in Ontario, although there are uh, restrictions around arbitration that don't exist in some other jurisdictions, namely the United States. Especially courts are more likely to find an arbitration clause unconscionable here, depending on what it contains. Um, but like the why shoot ourselves in the foot if arbitrators are providing affordable and again to the extent that they're not affordable, it's a supply issue with lawyers. If they're providing affordable, just outcomes that people are satisfied with, and they're not running afoul of the law, I mean, that is an amazing service that we should be lauding, and perhaps this report should look into that a little more. So, add this to the list of people to talk to, private arbitrators, alternative dispute resolution. It's going to happen more in the future, I guarantee it, unless it's outlawed. And in which case, you're going to end up with something more like the Canadian medical system, right? Where where you do have still a private and a public system interacting, and you're going to have long wait times and access issues in that respect, right? So, I mean, I guess you have to balance access issues with can everybody afford to pay for private arbitration? No. But if you make the system sort of rebuke private arbitration and you just want to cha make small changes, nobody is going to access the justice system, which is apparently in crisis and facing severe delays. Where are your values, right? And when you're answering that question, remember, who is this serving? It doesn't just exist for its own moral reasons, the system. It's supposed to be for people. It's an instrument to get people what they need. Um, Eventually, litigants are warned that it only makes sense to settle lest they incur more time, cost, and stress. A settlement driven primarily by the need to stop the drain of resources is not rooted in justice. I very much agree with this sentence, and this is something that I find very disturbing about our system, but also that annoys me about this report. Um, and that is that people who go to a justice system should be getting justice, right? You shouldn't be scared if you have been truly wronged to bring the issue to a head. And in fact, the justice system presently, and this report wants this to be more ubiquitous, forces the greatest contradiction in terms I've ever heard, which is mandatory mediation, right? Mandatory mediation is not possible, by the way. That's just a forced negotiation. Mediation, when you're taught how to mediate, it is always emphasized that that is a voluntary process and that it does not work without a voluntary basis. But um, why does the government say you need to do mandatory mediation before you can get to a trial? It's because they want you to go away, right? That they want you to leave. They don't want you in the system. And that is a fundamental difference in outlook between a supply managed system on a budget run by a government and a service provided by a business, which will see the person who requires dispute resolution services as a client, right? And they're not going to make you necessarily go through hoops that you don't want to go through or that don't make any sense because there's no reason to mediate something. Perhaps you are, I mean, plenty of people, and I have seen this repeatedly, go to mediation just to tick the box to say they've been to mediation. Well, what kind of a waste of time is that, right? The only reason it persists is, again, they just don't want you to be there, right? So, um, anything that the court can do to get you to settle and go away will generally do. And I don't like that at all because it doesn't, in fact, get to the truth of the matter. It doesn't reinforce the norms that society relies on. Um, and I think that you'll find the reforms that this thing mentions are designed partly to get people to go away sooner, and I'll get into that. Um, so we have moved from being a society governed by the rule of law to being a society governed by the law of rules. We have become so completely seduced by the notion, borrowed from criminal law, that process ensures justice, that we have come to believe the process is justice. Yet, to members of the public who find themselves mired for years in the civil justice system's process may be the obstacle to justice. It may be time to rethink how civil disputes are resolved. Okay, I guess, but look, the process is actually supposed to be, um, it's supposed to tease out the truth, right? The common law system, we have an adversarial process where both parties or all the parties are going to argue about what they think is right and what is true and what has happened and what should happen. And somewhere in that, the judge or a jury will have to decide using, all their faculty, what happened and what should happen. And if you don't have a robust process for figuring out what should be mentioned, what can't be mentioned, how it should be mentioned, what instructions should be given, who should be misled, or sorry, or how to prevent people from being misled. Um, these sorts of things, you will not arrive at a just outcome, right? So it's easy to sort of complain about the process of the justice system, but it is required by the limited knowledge that humans have, right? We don't know. We weren't there. You need to prove it. Um, it's rather scary to me, actually, the way that people have been moving towards systems that don't require as much process. Um, and I have some direct experience with this, with a particular tribunal in Ontario um, that unfortunately is also, I've learned, being emulated in Alberta soon, where, look, the courts are busy, they set up a tribunal, it's an adjudicative body, it's not a judicial body. And then what are you doing? You're arguing about issues online. You're writing out arguments online um, with no oral examination, with no real hearing except for a paper hearing. Well, I say paper, but it's electronic, with no evidentiary standards, and with decisions that, while non-binding, are persuasive and affect millions of people. And I don't think that's right, and I don't think, from my experience, that it results in very good decisions. And so, if that type of thing, that which, by the way, would be illegal in some other countries, and I'll get back to that, if that is how the Superior Court is going to start to lean, I'm a little unsettled. I don't like that, and it's not, I don't think it's just me either, because if I look at that Phase One report, I think several of the lawyers don't particularly like these ideas. Um, so. What did I want to say? Have I covered everything before moving on? I think I would like to, before I go into some of the changes that they're suggesting doing, just make one more appeal for, pun intended, for empirics and the need for statistical and objective rigor in this reporting. Because you'll see, like, a lot of the references in the footnotes. I mean, not that there's anything wrong with the references in the footnotes. It's just it's a lot of legal references, a lot of I mean, the Charter of Rights and Freedoms. You've got court cases. There's a lot of legal reasoning here, and obviously, I'm I like that type of reasoning as well. There is one mention of Statista in here, the website, the statistics website, and I believe that's where they pulled the number of litigants or litigation actions occurring in applications in the courts. Um, but this is incredibly serious, right? So uh, it's not enough to say, which this report does, that the UK has done similar things and that Australia too is doing similar things, and New Zealand also, and they seem to be doing well with it. Well, on what metric are they doing well, right? So, in for example, take that tribunal I was talking about earlier. Well, it has resolved thousands of condominium disputes. Has it resolved them well? How do we know? Was it worth the expense that people pay? Not the direct litigants, mind you, but the broader society to get that tribunal instantiated. It costs almost nothing to use the tribunal, so how do we know that it hasn't actually incentivized thousands of applications to it? In fact, it probably has for for standard economic reasoning, right? When you make something very cheap, you will get takers. Um, It's not clear. This work has not been done, and it hasn't been done in England or Australia or New Zealand either. And there are reasons to think, actually, that their justice systems, which have been also strained, um, are not as good as the American one. And I know that's not going to be popular to say. I'm aware of that. Um, but I'll explain it. And I don't think I'm coming to a conclusion here so much as inviting listeners to think about this and somebody to do this work, right? So here's a paradox for you. The United States is by far the most litigious country on the planet. There's no one that's even close, right? I mean, better call Saul, right? There are lawyers all over the place, and there are people in those courts arguing all the time, and it's expensive. Lawyers are expensive in the States too. But how do you resolve that paradox that there's so much litigation and yet they're also expensive? And here's how. There are different ways to access justice that don't necessarily trample on due process, right? What we're talking about here, and I don't think the term even comes up. I'm gonna check. No, process comes up, but not due process. And that's, I know it is an American term, although not exclusively. But in the United States, this entire what well not maybe the entire thing, but much of what is suggested in this report, those tribunals that I was talking about, including landlord tenant and the condo authority tribunal, whatever other tribunal you can think of that does these online paper decisions, would be unconstitutional. And that should give you pause to think about this for a minute, right? Set aside any tribal instincts you have about the United States. Try to remove the current president of the United States' policies and however you feel about that, whether you're for the policies or against them, and consider the following. The United States is far, far more successful economically than England, Australia, and certainly Canada. It's also closer to Canada, not just physically, but societally. We consume much of the same media. We have a lot of the same values. People will scoff at that, but it's true. Um, and maybe that has diverged more over the past few years, but historically, um, we've had more in common than not, and I think that's still true. And yet they don't skimp on due process, right? In fact, it is, I don't know if there's something more important in the United States. You have freedom of expression, right? That they've got well, they don't use that's a Canadian term, but they have the same thing, freedom of speech, which the concepts are the same. You've got due process. You've got a myriad of other rights as well, but those are the biggest ones, right? Um, Maybe it should be that way. So, uh, here are some ways that the Americans deal with the expense of being litigious, which they are. Um, and by the way, I'm not saying the American system is perfect, but number one, awards are bigger. We don't do large awards in Canada. Unfortunately, because we don't do large awards in Canada, we disincentivize lawyers from picking up cases off poor people. In the United States, if you are a person who is impoverished and you are harmed by a powerful company or the government, you are going to find you're going to find a lawyer who will take up your case and only get paid if they win. That is common. It's like something like a third of plaintiff lawyers are working only to get paid if they win a settlement or in court or whatever, right? So who is absorbing that cost? It's not the impoverished plaintiff. The lawyers are absorbing that risk, right? And that's great. They incentivized that. Litigation, by the way, is not bad. They're not telling you to go away, right? By making large awards. In fact, that is a big incentive to see things through. Now, that can be an incentive to settle as well if you're scared of having a massive award against you. But it's certainly not the court saying like, "Hey, you should go away," necessarily, right? The I'm sure there is some of that, and it will vary widely by the state. But there's no court that's like, "Hey, let's remove due process and pay out nothing," in the United States. That's not a thing. Another thing is the United States is not scared of arbitration. There is more arbitration there by far compared to anywhere else. And that's good because a lot of the litigation that we have in Ontario is insurance based. It's insurance companies suing other people, other insurance companies. It's inefficient. I mean, maybe insurance companies, here's an idea, should have their own court, right? Like maybe they should have their own system to the extent that I don't know that that exists at all in Canada, but in the United States, the insurance companies tend to just have arbitration agreements and handle things through private means. And what's wrong with that? Who is that hurting? Nobody. In fact, it leaves more space in the public system for other litigants. Um, and yet none of this is addressed in this report. It basically glosses over. It acts like, well, only those other Commonwealth countries, the United Kingdom, Australia, and New Zealand are to be mentioned, and they're trying some of this, and hey, they seem to like it. By what metric? I don't know. That's not that math isn't done. And there is no robust comparison to other options like the American class action or plaintiff lawyer funded litigation or the proliferation of private processes in the United States. And I think that's a mistake. And I don't think that when you're dealing with um, changing a system that affects millions of people, that one can afford to ignore that on what I suspect are likely just biased grounds that don't stand up to reason. Um, so yeah, I know I passed the bar in DC, and you're thinking, well, of course he's going to say that, but really try to separate politics from reason. And that's always good advice. So, what am I talking about anyway here with this due process? What is this report saying might be a good idea for Ontario to engage in? Let's get into that a little more. Um, Overview of the proposed new framework. So again, they really don't like motions, uh, clogging up things. They don't. We have an adversarial system. And so it's not really surprising that the adversaries argue about how things should be conducted and what things should be left off of a claim and that sort of thing. They don't like it, so they would like to reduce the number of motions that a motion, of course, is sort of like a mini trial within a trial where you're arguing to the judge that some things should or shouldn't happen. I don't like the idea of not including motions. The reason that they don't want to include motions is that they're expensive to argue. But then my response would be, yeah, but people argue them anyway because they they're important. So maybe work on making them less expensive rather than getting rid of them. Um, in any case, that's not the only complaint that they have. Um, they want to change the way things are done so that it's a more upfront model. I think they call it that. The way it is right now, in broad strokes, you have your pleadings phase where people start an action or an application, they begin litigation, they're going to explain what it is that is going on to the other parties, and a complaint, or sorry, a claim is given, and a defense is demanded. Um, and those that's usually pretty quick. That's probably the quickest part about litigation. After that, you have to get all these parties together, and sometimes there's a significant number of parties in one litigation. For examinations for discovery. And part of the examinations process, the two that I'm going to focus on anyway, are an exchange of affidavits and documents. Presently, you need to send over, you're supposed to send over all documents related to your claim or your application. And of course, this is a lot of documents sometimes, and the report complains that in the modern day and age, documents are easier to create because emails are so prolific compared to letter writing and that sort of thing in the past. However, what it doesn't mention is that also documents are easier to bundle. They're also easier to scan through. They're easier to search. They're easier to read. So I don't know if it really is any worse, honestly. Numerically, it's worse. There's more documents. However, the tools we have to go through them are much better than 30, 40 years ago. So that's one thing is the exchange of documents. And the idea behind this exchange of documents, famously, I don't remember who said this. I think it may have been Lord Denning, that there's no more, what is it, trial by surprise or something like this. From now on, everybody will be litigating with their cards facing up on the table, right? So you're not going to have a big Matlock surprise moment where some new evidence is is elicited and something new comes out at trial and nobody's had a chance to um, research it and test that evidence. Um, Unfortunately, this system wants to do away with that expansive exchange of documents. I'll come back to that in a minute. The other part of examinations is the production of a witness. So there's an opportunity to cross-examine. Cross-examine is when you have the opposing counsel asking probing questions of the witness. Um, there's an opportunity to cross-examine a witness for each party in Canada in the discovery process. In the United States, again, this is even more expansive in depositions. The people want uh, to generally depose everybody they can, right? And this creates on the record statements where often parties will learn new things that they didn't understand before. It'll cause them to reevaluate their position. It'll cause them to ask for more documents for clarifications. They're called undertakings. And it gives also strategic information. By nature of what happens, this is not necessarily the point of examinations, but this does actually affect things. For example, you will now know how a witness presents, and that's important. Everybody knows it's important. It shouldn't be important, but it is, right? And that will affect how everybody sees their position. Um, Oral examinations are also important because the record of the examination can be used to impeach that witness later, right? So if they say something that contradicts something they said in examinations, now the credibility of that witness is damaged. You can't do that if you don't have an oral examination. And an oral examination keeps pressure on somebody. There are positives and negatives to this. The negative is that sometimes you're going to get inaccurate answers because the person feels pressured and panicked. The positives are that sometimes you're going to get more truthful answers because the person doesn't have time to confabulate, right? And there's a general, or at least there has been in the past, a general preference to run the risk of getting inaccurate answers because the person is panicking, which not everybody does, by the way, under cross-examination. Um, they prefer that risk than not being able to test what the witness is saying. After all, the witness is is giving evidence. They might be accusing somebody of something. And if the party can't confront their witness, again, another right explicit in the United States, then they can't have due process. You can't test this evidence. And by the way, the United States, in case this is a real hang up for anybody listening, did not invent any of those concepts that, right? This came out of years of wisdom in the English courts. Um, so the idea here is to do away with both of these things. No more oral examinations. You're just going to get your oral examination at trial. And you also no more robust exchange of documents. You're going to have to just include upfront the documents that you plan to rely on. And then if somebody wants something else, they can ask for it using this Redfern document disclosure schedule type of instrument. Okay. Now, what this does is it front loads litigation. So right now you have a statutory limitation of 2 years from when you knew or ought to have known that you should sue, yada yada yada, or your statute barred from proceeding in court to make a recovery. They want to give 3 years now instead of two, in recognition that lawyers will have to do more work sooner. Um, Two things to say about that. One, that lawyers will have to do more work sooner is not likely to make things less expensive. In fact, that's likely to bid up the time of lawyers and make them more stressed out and make them quit and have fewer lawyers, etc. But also remember that these limitation periods are not like a law of physics, right? This is something that the government has done to reduce the claims that it has to deal with. And now you have, by the way, in like almost every construction defect, there's a whole myriad of types of claims where statute of limitations is raised every time, just automatically, which is silly and creates a lot of issues. There are reasons why you might not want to hear an old claim, and that's those are evidentiary. Like, it's hard to rely on evidence from 75 years ago, and nobody is alive remaining to testify or verify the accuracy of it. And I understand that, but why not leave the court to decide whether that evidence is any good, instead of having this unnatural imposition, which, by the way, causes a lot of stress and it doesn't it really doesn't serve another purpose other than just getting rid of claims. It so yeah, the general idea here is to have more upfront witness statements, more upfront documents, less discovery. This is also concerning because, of course, the um, party that is suing is now making decisions about what is being relied upon, and the other side doesn't get to know what other documents exist necessarily because they have to request them and be specific about their requests. So again, you're moving away from proper due process. Another thing is that, excuse me, motions will not be allowed as often and will have to be approved by the court, um, or somebody who would be in charge of that, I guess, of motions if permitted. And you would have, in some instances, a paper record, a dispositive, excuse me, a dispositive motion, or sorry, proceeding that might not contain any oral examinations or have any evidence testing other than sort of that tribunal style that I was explaining earlier, where you're sending in things that you're relying on, and somebody reads it and just makes a decision based on their understanding of what's been read or but what's been written. Um, I'm not a big fan of any of this. At the end of the day, this is why I said maybe a moral philosopher needs to be involved here too, because this is about values. What do you value? Do you value a cheap expeditious process, or do you value getting to the truth of the matter? And I value the latter more, even as somebody who, is also subject to all of these things. I would rather make sure that my proceeding, if there ever is one, um, is dealt with in a very open manner with stringent testing of evidence. I really do not like the idea of a paper-based dispositive hearing. There are some things, however, that I think make a lot of sense that they're suggesting, things that are less controversial. I don't know if I'll be able to find the list now that I've gone on my my high horse rants here, but the some of them are having a single portal, a single form with which to start litigation. That makes sense. Identifying central issues is fine, that makes sense. However, I don't like the idea of forcing people to agree on what the central issues are if that's a matter of contention. Pre-litigation processes are something that I think make a lot of sense too. I don't think they should be binding, but they should be sort of a best practice. Don't sue somebody if you haven't even sent them a letter telling them what the problem is and what you want, right? And I know that courts don't like it when you do that, and I don't blame them. We don't want to make that normal. We want people to work out their differences, like civilized human beings would, right? And so I know the UK does have pre-litigation processes that I think do make some sense. Like just you have to send a clear demand letter to the other side. Um, so it's not all bad, but I guess here's my question. Having a one-stop shop portal that probably should have been implemented a long time ago, and front loading your litigation and reducing due process, um, and discouraging motions. Um, is this likely to save the justice system in any measurable way? No, right? Like the answer is no. It won't. These are just that people are hemming and hawing about it in report one is an indication that, maybe people would like to solve these problems without reducing the services being provided or the due process protections that people enjoy from common law. Um, and if I am going to get um, a little, let's say, emotionally motivated, this is a push away from common law. Again, we keep seeing these pushes away from common law, and towards a more civil process. And by civil, I don't mean like civil law in the common tradition. I mean civil law like Quebec, Louisiana, France. Now, I'm not denigrating those places or the way they choose to handle their justice system, but it's a big change for Ontario, and I don't like it. I because I don't like the idea that the parties are no longer the ones in control of their litigation, and that it's this central judge, and that the judge is now the one doing more of the investigating and deciding about what we're going to argue about. This is more like a civil-based system, a codified system. Um, and there's even more evidence of that because I'm not going to bother finding it in the report right now, but they go on to talk about experts and expert reporting in court cases. Right now, expert reporting is a standard, it's robust, it's required in all kinds of different cases. They want to limit the number of experts so that you can only have one per issue, which I don't know why the court would get to decide how you should be able to explain your case. But they also want to maybe even rely on shared experts more, which is more similar to a civil system. You can have a court-appointed expert now, to be clear, right? And all of the experts in Ontario have a duty to the court. They're not supposed to just fabricate for their client. However, I think that we're drastically changing the character of our the way we handle disputes in society if we're saying, look, we're going to have one expert, and that expert's going to tell the court what the court needs to know, and the court's going to decide that. And I mean, we're not even going to argue about who the expert is. I mean, that's going to be a massive problem. Obviously, the two sides won't necessarily agree. Um, I can even see it being a practical problem in some cases, especially the sort of construction defect ones that I'm most familiar with. And so aesthetically, let's say, I don't like the civil system as much as the common law system. Um, but I'm not hanging my hat, so to speak, on that alone. If the civil law system works better for people, it's something that we should adopt. Um, However, and I'm going to wrap things up really shortly here. This is a nice segue back to one of my initial complaints about the report, which is that it's lacking empirical evidence. Show me that a civil law tradition is better for societal stability, better for the economy, better for truth seeking, that it's more thought out, more epistemologically sound, that it's more rational, logical. I'm open to it. I do have my biases like any other person, but I'm open to it, but it's not in this report. You're not going to find that. You will find recommendations that shift in that direction, but that's because, oh, we're begrudgingly doing this because there's no resources coming, and there's this false dichotomy that, hey, it's either accept the way it is, or, we're going to have to make these little piddly changes. And by the way, your due process is just not that important. Um, you know, I I know I'm being a little snippy there, but th that is kind of how this report reads, although it's much nicer in tone. So there you go. I know this has been a long one, and it's a little different from my other offerings, let's say. I am going to keep an eye on how this progresses. I will be writing out a lot of my thoughts to send them to the court for consideration before the deadline, and I think it's in June. Um, and I'm sure um, well, I don't know. I won't be so cynical as to say that they won't be listened to at all. But if you care about this issue, even if you disagree with me, make sure to look this up. It's going to affect you or a loved one or your business or something. So make sure to find this. You can Google this document. It's very easy to find. Check out both phases. And I'll just say again, they need to involve more people who aren't lawyers. They need to check their premises again because once you get past page two, the rest of the report, is just going to be an exercise in minutia. And then on top of that, they need to work more on proving their statements. They need to work more on proving their recommendations will work, and not just on a metric of, well, England's doing it. Well, really, how is it working out for them? Reducing wait times is one metric. Don't forget to offset it, right? So, like, if there's less delay in England than in the United States, but then in the United States you have better outcomes and people are happier with it, who wins, right? You're going to have to make a value judgment, but at least put the data in here. Take that time to do that. Compare the civil system with the common law system. Just be upfront about what you're doing. And at least everybody who's affected by this is owed that if we're going to make these sorts of top-down decisions. All right, well that's enough, I think. I do have other ideas, but I'll save them for another one. Another episode. Thanks for listening. If you made it all the way through, I hope that this was at least somewhat entertaining. I won't be surprised if several people really are upset with me now. But you know what? This is important, and it's not something that you hold your tongue on when you have your justice system that self-reportedly is extremely important for the stability of society. When people are talking about changing that, you better be honest about your opinions. So there you go. Looking forward to the feedback and thank you and see you next episode.